So the next area we are going to start about is the appointment of various directors. So various appointments we are going to discuss in this connection, a rapid revision on the same. So let me first give you the sequence of study, the learning objectives of this part 2 of director session. Number 1 will be first directors, 160 director, rotational and non-rotational director, additional, alternate, nominee, casual vacancy, women director, Indian resident director, independent director. First we need to complete these. You may ask a question, sir, small shareholder director and proportional representation, that is a interlinking directors. What is the concept behind that? We will learn when we come to that area. First we have 10 learning objectives to complete. Minimum 2 questions will come in examination from this 10. Definitely you can expect 2 questions to come in examination from these. Marks irrelevant, 2 2, 3 3, 4 4, any pattern it can come. Combination is also possible. A combination of 3 marks and 5 marks, 3 marks and 3 marks, 3 marks and 2 marks, 3 marks and 4 marks. Any combination can come. 2 pakka questions will come from the areas. That means 10 questions we are going to read now. From these 10, 2 can be coming in examination. Generally, 99 cases it will come mandatorily in exam. So let us first start with our first concept, the first directors in a company. So the first directors are governed by section number 152 subsection number 1. What it is talking about, let us have a look. First, before we start with the concept, who is a first director? Whenever a company gets incorporated, we need to require to have a minimum number of directors or not. Minimum number of directors in case of a public company will be 2, private public company will be 3, private company will be 2, and OPC will be 1. Okay, I'm not talking about maximum. Minimum directors requirement is there for all the 3 companies, having a 3 to 1 respectively for public, private and OPC. That directors must be there from the date of its incorporation itself. Okay, so the first director section speaks as follows. Revision session, let me revise the concepts clearly. So the first director, mode of appointment. For every director we need to check 2 things: mode of appointment, tenure of office. Mode of appointment, tenure of office. For every director, each and every director we need to check 2 things: mode of appointment and tenure of office. Okay, in normal class sessions we use it to refer everything from a Baer Act and try to reinterpret that. So we interpret using a Baer Act. Since this is a revision session, keep Baer Act aside. Nonsense. If you read Baer Act in a revision session, then there will be no difference between both the revision session and a normal. So in a normal session we go through the Baer Act very clearly and very much in depth. Revision session, already you have an idea about who is the first director. Let us revise the concept very quickly. So first directors. First directors are governed by section number 152 subsection number 1. 2 things we need to check: mode of appointment, tenure of office. First directors can be appointed in 2 ways. Way number 1, specify the names in the articles, or articles may be silent. If the names are already specified in the articles, the persons so named shall become the first directors. If the articles is silent, a company cannot get incorporated without first directors. Automation will apply. Subscribers to the memorandum who are individuals, subscribers to the memorandum who are individuals will become the first directors of a company. That means if the articles specify, follow articles and appoint them as a first directors. If the articles is silent, then automatically the subscribers to the memorandum who are individuals will become first directors in a company. Okay, clear. Next issue, tenure of office, till when they can continue. Now listen carefully. First directors concept we can divide into 2 parts: mode of appointment, tenure of office. Now answer my question. First one, mode of appointment can be of 2 types. First one, mode of appointment can be of 2 types: article specify, articles of association is silent. If articles specify, persons specified in the articles will become first directors. If articles is silent, what will happen? Subscribers to the memorandum who are individuals will be deemed to be the first directors of a company. Okay, I am first director or deemed to be a first director, deemed to be first director. Now I am normal person or subscriber, just a subscriber to the memorandum or a founder members. The company when incorporated, who become the first members of the company are called as subscribers to the memorandum. Generally, they will be the promoters. Simply the logic of the government is promoters will become the directors. Therefore, they are called as a promoter directors, deemed first directors. So, subscribers to the memorandum need to have a DIN. Is there any mandate that subscribers to the memorandum need to have a DIN? No need. Subscriber to the memorandum need not have a DIN. That means these deemed first directors need not even have a DIN. In general cases, DFD will not have a DIN because they are subscribers to the memorandum. If they are also having a DIN, they would have become directors directly through the articles. So therefore, the deemed first director, presumably law presumes that these deemed first directors don't even have a valid DIN. Okay, one important point in this connection. Whenever company is incorporated, the first annual general meeting of a company must be held within 9 months from the close of first financial year. Example, my company got incorporated on 10th May 2020. For example, 10th May 2020, my company got incorporated. First financial year end on 31st March 2021. From this, add another 9 months. It come to 31st December 2021. That means a company which got incorporated on 10th May will have its first AGM, the maximum date, the last date for holding the first AGM will be 31/12/2021. Now you may ask a question, why suddenly you are discussing about first AGM date? There is a relevance here. Tell me, if the first director has to be appointed, there are two ways. First one, mode of appointment. Articles may specify, articles may be silent. If articles specify, follow that and appoint them as a first directors, officially appointed. But if the articles is silent, can we have a first directors? Can we have a company without first directors? No. So deemed first directors will be there. STM being individuals, he said that's all. STM having a value, DIN being individuals, he didn't tell like that. So STM being individuals will become deemed first director. That means they need to have a DIN, need not have a DIN, need not even have a DIN. They become the deemed first director of the company by default. Now tell me, if these persons not having a DIN, DIN is what? What is the importance of it? Whenever directors of the company contract on behalf of company, on the contract papers, they have to sign and write their DIN number. Then only the contract will be executed. If I don't have a DIN, how can I quote the DIN? That means these deemed first directors are appointed only for emergency. That means since a company cannot get incorporated without first directors, in the case of emergency, I appointed you to be temporarily acting as a first director, but don't act anything. Am I clear or not? That means company is a artificial person. It's a car, vehicle. It's a car. Let's take a car. Okay. Now, what is the logic of the government of India or the MCA in making subscriber to the memorandum being individuals as a DFD? I will give a classic example to every one of you. So listen carefully to the point. I purchased a car. After purchasing a car, I also appointed a driver. Okay. Now, car is a physical, natural person or artificial person? Artificial person. I am the owner of the car, I am the driver of the car, I am the owner of the car. I purchased the car for 10 lakhs. I appointed a driver. Now, three entities are there: car, owner, driver. Now, car is an artificial person. Driver is owner is a subscriber to the memorandum, the person who purchased it, owner. And driver is a director who drives a particular company, that particular car. Now, represent like this: car is a company, driver is a director, and I am a subscriber to the memorandum. Okay. Now I will ask you another question. Please make your answer self and then answer this. Point number one. I purchased a car worth rupees 10 lakhs. Okay. I didn't appoint any kind of driver. What will be your presumption? Tell me. I purchased a car. I don't have any kind of appointed driver. Then what will be your presumption in this case? What you will presume? This car will run without a driver. Huh? No. What you will presume? I will drive the car. Who I am? I'm a person who is a driver, or a person I'm a owner. That means if the driver is not appointed, we assume that the person who purchased the car will drive the car. If this presumption is right in case of a car, why can't government make the same presumption in case of a company? That means, tell me, I purchased a car, I didn't appoint a driver, then I will drive the car is a general presumption of the public. Yes or no? But I don't have a driving license. Then I am capable only to start the engine. That's all. I don't have any capability to drive the car, gear up, acceleration, etc. I don't know. But public presume that I am the driver of the car. If no driver is appointed, then what purpose you purchase the car? So second, same logic applied to the company. Government of India treated car as a company here. Okay, driver as a director, owner as a subscriber. If subscribers to the memorandum at the time of incorporation write the names of first directors in the articles, they will become the official drivers. Owners, please sit at the back. But if the company, being a car, does not have any kind of officially appointed driver, we presume that persons who purchase the car or persons who invested in the company will drive the car, will drive the company. That's why subscribers will be deemed to be the first directors. That's the basic logic of the government of India. This is how the section was drafted. Okay, but in the previous example, what I said, I purchased a car, I didn't appoint any kind of driver to that car, and I also don't have a driving license. Presumably, if you have a driving license, well and good. If you don't have a driving license, are you capable to drive a car? Appoint driver as soon as possible. Same even in company law. If you don't have a DIN, you can't contract on behalf of company. Then what is the purpose of purchasing a car? What is the purpose of incorporating a company? Therefore, see here, law says like this: if names are specified in the articles itself, these first directors can continue for a long period. These first directors, officially if you are appointed, these first directors can continue till the long period. They can continue till the first AGM. They can continue till what AGM? First AGM. Let's write in the tenure of office. So mode of appointment, two modes. Now tenure of office, two tenures. If you are coming into the first case, that means articles specify the names: official, unofficial, official. These first directors can continue till the first AGM. In the first AGM, they need not vacate the office and go away. They can continue in the office and get nominated either as a rotational director or non-rotational director under section 152 subsection number 6 clause number C. Okay, what is this? We will come to 152.6 because it is a revision session. Already the persons who are listening will know what is 152.6 C60. So the first directors need not vacate at the first AGM. They can be continuing till first AGM. Even in the first AGM, they need not vacate. They will be nominated either as a rotational director or non-rotational director under 152.6C. And if you are from the second route, first we need to throw those no license drivers. So therefore, the deemed first directors will be appointed generally. First, there is a sequence here. Date of, sorry, see here. Date of incorporation, first AGM. Okay, date of incorporation, first AGM. Let's take this is 10th May 2020. Last date will be 31/12/2021. Now tell me, do the subscriber to the memorandum, as our presumption was made, have it in, not having it in, not having it in? Can you continue with a person who is not having it in for almost 15, 16, 18 months? Then company will be wind up in the first month itself. So I don't have a license. Will you give me a chance to drive the car, the newly purchased car? No. Just to switch on the engine, I am capable. Likewise said, just to incorporate the company, we are capable. Not to run the company, not to drive the car there. Okay, try to understand that. So therefore, the date of incorporation is 10/5/2020 and the first AGM is on 31/12/2021. Okay, 2021 is a first AGM. Therefore, don't entertain these deemed first director for so long period. Conduct a EGM. conduct a EGM next after incorporation but before first EGM. In this EGM, the deemed first directors will vacate the office and places will become vacant. These vacant places will be filled under section 160 by new appointments. These people are called as first directors, not deemed first directors, first directors. These first directors will follow same procedure whatever we have seen here. These first directors need not vacate at the first AGM. Need not vacate at the first AGM. They will be nominated as a rotational directors or non-rotational directors. This is the idea behind this particular concept. Okay, this is all about the first directors concept. See here, tenure of office. If the article specify first director so appointed shall continue till first AGM and there they will be nominated as rotational or non-rotational. If AO is silent, conduct EGM immediately after incorporation but before first AGM. In EGM, the deemed first director shall vacate and such vacancy shall be filled in accordance with section number 160 and these people will be following the same procedure. Next issue, 160. 160 talks about a new person to apply for a directorship. So the section will be called as right of a person to stand for directorship other than retiring director. You can also call this section as right of a person other than retiring director to stand for directorship, or right of a person to stand for directorship other than retiring director. Anything is correct. So what is the section number? Section number 160. What this section talks about? Section applicability. This section applies only to public company. Okay, next issue. So again, revision session, keep it on hold like a revision session. These sections individually will take almost 2 hours, 3 hours at the normal session range. So I just don't want to convey my knowledge in revision sessions. Okay, I need not boast about myself in revision session. These are the things that I know. Here, greatness of any person dealing here is not important. What you understand already and how we are going with the revision is important. Okay, so please don't expect in-depth points because we are on to the revision points. Okay, listen. Precondition for the appointment. Now, first one, right of a person is the word used. What is the mean by a person? Not already a director. That's all. So, section applicable to which company? Only public companies. And precondition, be eligible for appointment as a director. That means he should not be disqualified and he should have a DIN. All these conditions should be satisfied first. Where section takes effect? Any general meeting. This can be either a EGM or this can be either a AGM. Next one, procedure. What is a procedure? This here they will issue a which notice? The person who want to propose himself for the directorship will issue which notice? Special notice. Like this, you should not think. Many times I heard from the students community 160 section we issue special notice. Nonsense. Why you will issue special notice at the time of 160? 160 is not a special notice. 160 is a 160 notice. That's all. It's not a special notice. Characteristics of 160 are similar to that of special notice concept, but not a special notice because special notice can be given only by a member. Here, outsider can also make a notice. So please listen carefully. Who is eligible? Member himself can propose his candidature. I am a member of a company. I can send my own candidature for appointment. Member can propose others. Others can propose them. That means self-proposal is possible. Others cannot propose others. Others represent non-member. Non-member giving a chance itself is a boon. Itself is a great. Then you should not propose outsiders. Don't do overaction. When I give an outsider a chance, avail yourself. Don't give the coupon to others to avail. Okay, so therefore tell me first section applicable to which company? Public companies. First tell me what is the section? Right of a person to become a director. What he has to send? Notice. Notice to whom? Company. Company who should send a notice? It can be sent either by a member himself or member can propose member himself or member can propose others or others to themselves. Okay, where to send the notice? Registered office. Sorry, where to send the notice? Registered office. How many days before? Not less than 14 days before the meeting. And deposit of how much? Rupees 1 lakh. Next one, section not applicable to whom? For a retiring director, this section does not apply. Which section? 160 does not apply to a retiring director. Procedure as per the rules. First, before going into this, answer my question. What is the section number we are going to deal with? 160. Right of a person other than retiring director to stand for directorship. Name itself is telling right of a person to stand for directorship other than retiring director. Therefore, section does not apply to a retiring director. Why? We will come to 150 to 60. Then I will discuss why retiring directors are excluded from that. Next issue. After that, applicability of the section. Applicable to which company? All public companies. What is the procedure for appointment? Precondition is first you should be eligible for directorship. Next one, section does not apply to which director? Retiring director. Next one, where section shall take effect? AGM or EGM or both? Any AGM, any GM, either AGM or EGM. Who is eligible? Member himself can propose his candidature, member to others, and others to themselves. Others to others not possible. So we have to submit in the registrar office. How many days before the meeting? 14 days before. Because of you giving a notice under 160, meeting will not be held. Knowing about meeting is going to get held, you should issue a notice under section 160 along with the deposit of how much rupees? 1 lakh. Deposit at the registrar office of the company. Procedure. Now tell me, answer this question. This I will explain clearly, though in a revision session, because this has some conceptual basic. See here. This is D0, D21. Date of general meeting, date of notice. Now listen carefully. First, what is issued? Notice of general meeting is issued. Member received, or through advertisement, non-member came to know that a company is going to conduct a AGM after 21 days. Notice came. Okay, that means public and the members are aware that this company is going to conduct its AGM after 21 days. Knowing about this, I have to give a notice 14 days before. I issued a I issued a notice under section 160 proposing my own name. Now tell me, who proposed the name? I proposed my name. How many days prior? 14 days prior. Knowing about what? Knowing about general meeting by giving a notice. Okay, so 14 days before I received a notice from the company. Okay, 7 days before I received a notice from the company that the company is going to conduct a AGM or EGM. After coming to knowing, after knowing about that, I issued a notice in my favor for getting appointed in that particular general meeting. Now tell me, who knows about my candidature at this point of time? Notice given to all the members of the company receiving after I sent a notice to board of directors proposing my candidature. That means my idea is communicated to two people. One is I know that I am going to propose my candidature, and two will be the board of directors. But who should know about this? Because the original notice what we sent 21 days before does not contain this agenda. This agenda came into existence 14 days after. Therefore, board of directors should not pass a surprise resolutions in the general meeting. Suddenly, 4 ordinary business are completed, 2-3 special business are completed. Later, chairman student said, now this is the time for appointment of Mr. A as a director under 160. All the shareholders are seeing their faces. Chairperson asked, why you are so much annoyed about this? What happened? Immediately they said that in the notice, whatever you have given, this agenda is not there. From where this new appointment agenda came? Then chairperson said, oh, I forgot. 40 days before we received a notice from one of the member to propose himself as a candidate for a directorship. You should have told us 7 days or 10 days before. You must have told us such that we will decide and come to the general meeting whether to appoint or not. Suddenly, if you tell, how can we take a decision for appointment or not appointment? So therefore, law says that you send a notice 14 days prior. This notice is sent by me. I know that I am going to propose myself and received by board. Board also know, but other shareholders should also be aware or not. Therefore, the board of directors has to communicate about this at least 7 days before the notice. Sorry, 7 days before the general meeting. This is what they said. When you are sending 7 days before, lesser time is there. Possible, give advertisement in 2 newspapers, one in English and another one is local vernacular language. If not possible, if not possible to send individual notice, do this. If possible, send individual notices to all. This is what said in this particular section number 160. So please have a look into the chart. Revision session should look like a revision session. So take a minute time. Please look into the chart properly. So next one. Reappointment of retiring directors. Reappointment of which directors? Retiring directors in a company. Now we are going to discuss about section 152. Technically 152 subsection 6 we are going to read with. So what is section 152.6? Just now we completed section 160. 160 is applicable for a person or a director person. That means who is not already a director of a company, that section will apply. If you are already a director of company, 160 will apply, or 152.6? 152.6. 152.6 applies to directors, 160 applies to the non-directors. So 152.6 is making a division of directors. What they are making? Division of directors. Section applicable only to public companies. It can take effect only at a EGM and not at a AGM and not at a EGM. And types of directors covered: rotational directors, non-rotational directors. So very big section. Let's complete this just in 10 minutes. Okay, because we are having many other sections also to cover up. So 152.6 section. It is applicable only to a public company, and it takes effect only at a AGM and not at a EGM. And the total directors will be divided into two categories: rotational, non-rotational. Next issue, various details. Now always we need to have three questions for every director: rotational, non-rotational, three questions. That means totally 6 questions are to be answered. How rotational directors are appointed, minimum number of how many rotational directors are required, what is the meaning of rotational director, what is the mode of appointment of non-rotational, minimum number of how many non-rotational are required, and meaning. Three things. First one, let us go from the last. What is the meaning of a rotational directors? Rotational directors are those directors whose office is liable to retire by rotation. Liable to retire by rotation, meaning we will discuss later. So liable to retire by rotation, liable to retire by rotation. I am liable. Okay, liable to retire by rotation is called as a rotational director. Minimum how many of the directors should be rotational? Not less than 2/3 of the total number of directors must be rotational. How they are appointed? Either at a general meeting or any other mode which is specifically specified in the law. If rotational directors are appointed in any other mode other than in a general meeting, follow that. If nothing is said, rotational directors will be appointed by company in a general meeting. Next one, non-rotational director. Non-rotational director mode of appointment is either specified in the articles that he is non-rotational. In all other cases, general meeting will appoint. Okay. Next issue, minimum number of rotational non-rotational director concept is not there. Maximum non-rotational directors will be 1/3. Remaining directors not less than, remaining directors not more than, sorry, not more than 1/3. That means if this is 1/3 with the maximum, this can't, this if this is not exceeding 1/3, then only this 2/3 condition will be satisfied. So minimum number of rotation will be 2/3. Minimum only 2/3. You can also have beyond but 2/3. If it is beyond 2/3, this will be lesser than 1/3. Therefore, don't tell non-rotational directors means 1/3. Non-rotational directors means remaining directors. That's all. This is a correct answer. Which director? Remaining director. It will be not more than 1/3 of the total strength. Okay. And meaning, these people are not liable to retire by rotation. Now tell me, sir, where we can see this? This is said in section 152 subsection 6 class A, subclass 1, subclass 2, and section 152 subsection 6 class B in the Bear Act. If you can refer to this, you will get the answers. But fast revision, point number 1. Total number of directors under this section will be divided into how many categories? 2. Rotational, non-rotational. First, meaning. What is a rotational director? Who is a rotational director? Who is liable to retire by rotation? How many minimum? Not less than 2/3. And how they are appointed? Generally, general meeting will appoint. If there any section or any provision says appointment of rotational director in some other way other than general meeting, follow that. If nothing is said, rotational directors will be appointed in a general meeting, probably under section number 160. Okay. Non-rotational director, meaning not liable to retire by rotation, maximum will be the remaining directors and maximum will be 1/3. And lastly, what is the meaning of a non-rotational director who is not liable to retire by rotation. So one part is completed. Next issue, part 2, manner of retirement. This section is such a section where this section take place every year. Every year. Now, everyone answer my question clearly. There are two types of businesses in a general meeting. Ordinary business, special business. Okay, ordinary business and a special business. And what are the ordinary businesses? First one, approval of financial statements. Okay, declaration of dividend, appointment of directors, appointment of auditors. Appointment of directors, appointment of auditors. All others other than these four will be called as a special business under Companies Act. Now answer my question clearly. Ordinary business, four businesses are there: financial statements approval, declaration of dividend, appointment of directors, appointment of auditors. Now tell me, section number 160 will be coming into ordinary business or a special business? What is section 160? Appointment of a director. So this is appointment of a director. Section 160 is an ordinary business or not, everyone? So section 160 is a classic example of a ordinary business. Like this, you should not think it is a classic example of a special business. Sir, appointment of a director is an ordinary business, na sir? Never. This is where students are again going wrong. That I want to convey, even if it is a revision session. Because these wrong areas, I want to make it right. Already known areas, there is no common sense in repeating that a number of times. Okay? Now, listen carefully. There are four ordinary businesses. Yes, that was correct. Approval of annual financial statement, declaration of dividend, and third one is reappointment of retiring directors, reappointment of retiring auditors, not appointment. Appointment is a special business. Reappointment is not a special business. Sorry, reappointment is not a special business. Reappointment is a ordinary. Appointment is a special business. Director appointment 160 is special, but reappointment of retiring directors is a quite obvious ordinary business in a general meeting. So this is what I want to tell, and your common sense should work always. If not working, you have to check yourself. Because why? Just now 10 minutes back I said section 160 can take place either at a EGM or at a AGM. At a EGM, no ordinary business, there will be only special business. That means 160 is a special business. That's all. That's how you should understand. So don't be under wrong impressions and wrong traps. So the main thing that we need to understand is appointment of director is not an ordinary business. Reappointment of retiring directors is an ordinary business, like auditors also with the same answer. Now tell me, what is an ordinary business? What is a special business? Ordinary business is such a business which happens in the ordinary course of business. Like this, you should not think. Sir, why sir? Ordinary business does not mean ordinary course of business, sir. Never. Ordinary business means a business which happens every financial year but happens only once. Tell me, declaration of final dividend. How many times you will declare final dividend in a year? 55 times, sir. One time. How many times you will approve annual financial statements? You are telling annual, happens one. Next, this section, reappointment of retiring directors will happen at a AGM. Happen at a AGM is AGM will happen 10 times in a year, one time. That means ordinary businesses are those businesses which happens every financial year but happen only once. So this is an ordinary business. So that means this happens one time every year. Why I'm saying all these things? To have a justification of the Bear Act 150 to 6C. 150 to 6C, if you see the Bear Act, they will use the word at the first annual general meeting and at every subsequent annual general meeting. Okay. So now, first AGM and every subsequent AGM, 1/3 of the rotational director shall actually retire. 1/3 of the rotational director shall actually retire. 1/3 means you can use a mathematical rule, because it doesn't use the word not less than 1/3. It uses the word 1/3. That means if you get 2.33, make it 2. If you get 3.67, make it 4. Okay. If it is 2.33, make it 2. If it is 3.67, make it 4. But 2/3, the above 2/3, rotational directors count of 2/3, not less than 2/3. If you get 2.33 also, you should take 3, because if you count 2.33 as 2, not less than 2.33. If you take 2, it is lesser than 2.33. So therefore, 2/3 mathematical rule does not apply. 1/3 mathematical rule apply. 150 to 6D. That means, tell me, if there are 15 directors in a company, total directors, how many rotational? 2/3, 10. How many non-rotational? Maximum 5. How many retiring directors must be there in this? How many should retire? In this, 1/3 shall actually retire. Okay, 1/3 means how many? 1/3 means how many? 3.33, which makes it 3. 3 directors shall actually retire. So therefore, that means the total directors are not just 2 now, they are 4. Total directors, rotational directors, non-rotational directors, retiring directors. Which director? Retiring director. So these directors are called as a retiring director. Which director? Retiring director. For them, 160 section does not apply. That's what they say. So why in classroom I use it to demonstrate taking a chair, okay, sitting and standing. Okay, now I can't do that magical moments again. So in classroom we can do that. Just you have to remember that these are retiring directors. For them 160 does not apply. What is the reason? In classroom discussion we use it to tell that. So who shall retire first? So tell me, 15 directors are there. In this 10 are rotational, 5 are non-rotational, 3 are retiring director will be there. Now first everyone will let it out. Sir, what is this rotation, non-rotation, retiring, etc.? Rotation, non-rotation means totally 15 are there. Totally 15 are there. In this company Big Boss show, some will come for nomination. The persons who come for nomination in this show are called as rotational. Everyone who comes to nomination will be eliminated. No, only certain people will be eliminated. Those are these people. That means these 3 people should ask the shareholders, మీకు గనక నా పర్ఫార్మెన్స్ నచ్చినట్లయితే, like that they should ask, if you really like our performance, please send an SMS to, like that they will ask. Here they will ask. In this 15, 10 are rotational, who are nominations, who are nominated to stand. In these nominated, only 3 are selected. 1/3 are selected, not 3. Don't mug up 3. 10 la 1/3 is 3. So 3 are selected. These 3 people will be the elimination. If they are reappointed, they will come back, or else they will go out. That's how section was drafted. So in this 15, which 3? In this 15, 10 are there. 10 la 1/3 means 3. Which 3? Every director don't want to like to stand before shareholder. No participant in Big Boss show likes to get nominated. Then how to nominate them? Therefore, seniors should retire first before. Okay, so who shall retire first? Those who have been longest in office since their last appointment shall retire first. If multiple appointments are made on the same day and there is a confusion who should retire, then they shall retire by way of an agreement among themselves. If no agreement, draw of lots, cheaty game. Next, at the AGM, 2 events shall happen at the AGM. Either retiring director must be reappointed or some other person must be appointed in his place. If nothing happens, meeting will be adjourned. If at the adjourned meeting also same thing persists, retiring director shall be deemed to be reappointed. Retiring director shall be deemed to be reappointed. So listen now. There are how many retiring directors in our example? 3. All the 3 directors will sit at a place. They will come and stand before the AGM. They have to get reappointed. Shareholders didn't, they will reappoint or they will not reappoint and some other person will come. They are in a confusion state. They could not take any decision. That means they didn't vote in favor of appointment. They didn't vote even in favor of not to appoint or not to reappoint. And no other new person also applied under 160. In such case, first time, if there is any confusion about what decision to be taken at a general meeting, I will first adjourn the meeting. Come after 1 week. Even at the adjourned meeting, you are in a still confused state to vote at the general meeting. I can't wait for another adjournment. Retiring director shall be deemed to have been reappointed at the adjourned meeting. But the deemed reappointment does not apply if the participant, that means one of the director himself, has shown his unwillingness to get reappointed or disqualified, didn't gone or became unsound or insolvent, etc. And resolution has been put to the meeting in the original meeting and lost. If you are lost at the original meeting, you can't have a deemed reappointment. Deemed reappointment will apply only if you can't have a direct reappointment. Okay, this point we will discuss later. Ordinary special and 162 is applicable in his case. Okay, 162 applicable in his case means how to understand this. 162 section we already read. 2 directors can't be appointed by single resolution unless you follow the procedure. 3 directors are there here as a retiring directors in our example. All the 3 made a clubbed appointment. Okay, made a clubbed appointment. All the 3 are appointed without a proposal resolution. Without a proposal resolution, they want to stand. Shareholders are confused whom to appoint, whom not to appoint. They didn't pass any resolution. Adjournment made. Again, these three participants came and stand. Again, shareholders are confused. This is a good person, these two are bad. If I appoint this good, all these bad persons will also come. If I avoid this bad, this good person will also go. What to do in this resolution? They are confused and they didn't pass any resolution. Adjourn meeting also no resolution passed. Then meeting will be again adjourned. Retiring directors will be reappointed. Retiring directors will be generally reappointed. But since this is a violation of 162, these three directors will not be deemed reappointment, shall not apply to these three. That's what you want to convey. A very big section we just completed in 10 minutes. This is the idea behind 152 subsection number 6, clause number C and clause number D. So this is one part of our discussion. So the next area we are going to start is the board appointments. Board related appointment. That means appointment not made by general meeting, but appointment is made by board of directors itself. There are 4 directors in this: additional director, alternate director, nominee director, casual vacancy director. This is the next set of 4 directors. Okay, that we need to cover. Once this is also covered, substantial portion of directors appointments will get completed. We'll be going into women director, Indian resident and independent. With that, the main directorships provisions will be over. So the next directorship, as I already said, additional director. So there are 4 directors totally: additional director, alternate director, nominee director and casual vacancy director. Let's go through all the 4 directors in a set. Okay, now first thing, applicability of an additional director. And by the way, one thing I want to show first, this chart will be on additional director, this will be for the alternate, and this on the nominee, and this will be for the casual vacancy, and this is a statutory appointment. So 5 pages will contain 5 different sections. If you read these charts properly, main agenda behind the additional directors will be completed. Generally, additional directors in a normal class session will be taking all about 2.5 to 3 hours. But we can't expect all these things to happen in a revision session. Section content I want to cover. Beyond this, there are almost 25 points that we can dig out from the additional director concept, that we can see our normal workbook that is given at the time of classes. So if you see that, extra answers will be available there, past exam questions, some points inside, etc. These are the crux of the main section content. Okay, so let us start with the concept. Additional director. So the additional directors, why they are appointed? Many reasons are there. Some reasons will be corporate urgencies will be there. All the directors may not be available at all the times in the company for authorization purposes or for execution purposes of certain documents. Therefore, one director should be always available, and that will be the additional director. And many situations, for example, in my company there are 4 directors. 2 directors all of sudden, public company, 2 directors all of sudden resign from the company. And once 2 directors resign, there will be only 2 balanced directors. But in case of a public company, it is statutorily required to have 2 directors or 3 directors, 3 directors. But my statutory limit falls to how much? 2. At this point of time, you can't make any kind of decisions in the resolutions in the meeting. If you pass any kind of resolution, that resolution will become void ab initio. What to do now? Only 2 directors are there. We require 3 directors to execute anything. Therefore, you can't pass any resolution at the board meeting except appointment of an additional director. That means only one resolution is valid when the statutory limit is fallen below the limit. So the only resolution that is valid is appointment of an additional director. So you can appoint an additional director in case of that particular number falls below the statutory minimum. Don't be under a wrong impression that whenever the number falls below statutory minimum, then only additional director concept will come. That is one of the reasons. So many reasons are there. Okay, let us try to understand each and every point in detail with regard to additional director. So applicability, additional director concept applies to which company? It applies to all the companies, whether public or private. Next issue. Every director we need to check 2 things, must and should: mode of appointment, tenure of office. What is the mode of appointment? Board of directors will appoint the additional director. Tenure of office, till when he can continue in the office. He can continue up to the next AGM or the last date on which AGM should have been held, whichever is earlier. That means if the AGM held before the commencement of AGM, before AGM starts, additional director vacate and come out. Okay. Next, if the AGM itself is not conducted, as per section 96 of the Companies Act, AGM will be having 3 dates of limits. Earliest of the dates will be the last date for holding the subsequent AGM. that date is also there. So that will be the should have been held date. If you already held the AG, if you already conducted AGM, at the beginning of the commencement of meeting, additional director office will come to an end. If you don't conduct an AGM, the should have been date will become the date of vacation of additional director. So this is the point. Next one, nature of section. Is it optional to appoint an additional director or mandatory? Optional. Next one, power is derived from articles. Power is derived from articles means the articles of the company must be specific about appointment of additional director. If the articles of association is silent, company cannot appoint additional director. The only remedy is either adopt to table F or either alter the articles. If you adopt a table F, in table F anyway regulations are there governing additional director concept. You can appoint additional director. Your articles is silent and you are not adopting table F. In such case, the only remedy is alter the articles of association and provide for appointment of additional director. Nature of appointment. Board may appoint. This is important. Who can appoint? Board of directors. Board of directors can take decisions in two ways: board meeting and resolution by circulation. Now, resolution by circulation is passing resolution from a remote places. That means wherever you are from your house, you can pass a resolution without having any physical board meeting. Now, board of directors can take a decision of additional director at a physical board meeting or at an RBC or both. Both are possible. So, board may either appoint at a board meeting or by a resolution by circulation. Next one, who cannot be appointed as additional director? A person who is rejected under 160, not reappointed under 150 to 6, and removed under section 169. That means these people are persons who fails to get appointed as a director in a general meeting. So these people are the persons who fails to get appointed as a director in the general meeting. These kind of people are ineligible. Sir, you may get it out. So the words used are who fails to get appointed. Sir, removal is not a failure to get appointment. Removal is not a failure to get appointment, sir. Then why this is also included? Removal directors cannot be appointed as additional director is not said in this section. It was said in proviso to section number 169 subsection number 7 says like this. Okay, next issue, event of appointment. This is very important. Event of appointment. So listen carefully. Since this is a revision session, I think everyone already know about alternate nominee and casual vacancy. I need not introduce why they are. So alternate director will be appointed if the original director absent from India for not less than 3 months. Okay, next one, casual vacancy director will be appointed when there is a casual vacancy. Nominee director will be appointed when you take some loan or a financial assistance. That means if the original director does not leave India for not less than 3 months, you can't appoint alternate. That means what is the event? Original director getting absent from India for not less than 3 months. And what is the event for appointment of casual vacancy director? Casual vacancy should be created first. No casual vacancy, no casual vacancy director. No original director leaving India, no alternate director concept. Okay, no loan taken or no financial assistance given, no nominee director appointment. But without any kind of event, you can appoint only additional director. That's why the Bail Act uses the word at any time. If you see the Bail Act properly, you will see the words at any time. What is at any time? You can appoint additional director at any time. There is no separate time limits. You have to do only this. You have to do only upon occurrence of this event. At any time, at the discretion of the board, if it is really in the best interest of the company, you can appoint additional director. Okay, so these are certain important points. But certain points are there to cover. So listen. Okay, see here. Point number 1. Can we appoint additional director for a fixed tenure? Means what? That means can we appoint additional director can be appointed at any time or not? That means can we appoint additional director for 4 months period? Possible or not?
Can we appoint at any time or not? Yes, we can appoint at any time. That's why can I appoint an additional director for 4 months from today? Yes or no? Yes. Yes or no? Yes. You should not think. So just now you said at any time. Yes, I said. Yes, I said at any time you can appoint, but you cannot prepare the tenure. Once appointment is only at the discretion of the board at any time. Once appointed, he can continue till he has to continue till AGM, subjected to his disqualifications and vacation. Okay, if he is not disqualified, if he is not vacated, if he does not resign, he can continue till the AGM. That means additional directors will be appointed for a fixed tenure. Possibility is there or not? No, not possible. This is the first one. Can we appoint existing director as an additional director? Existing director as an additional director possible? Not possible. Section uses the word person, therefore not possible. And moreover, another point is the word used is additional director. The director who is appointed should add to the existing number. If you appoint existing director as additional director, where is the addition of another director? Not possible. Next one. For the purposes of 150 to 6, for the purposes of 150 to 6C, rotation, non-rotation. Additional director is rotation, non-rotation excluded. Additional director is excluded. What do you mean by excluded? If there are 16 directors in a company, 16 directors in a company, in this one is additional director, first reduce this one, make it 15, then divide this into 2/3 and balance. That's all. That means additional directors will be excluded from the total. Why excluded from the total? Simple common sense answer. Let's take like this. This is the date of AGM. AGM starts at 10 a.m. Okay. Additional director office will come to an end at the commencement of AGM, not at the conclusion. If it is conclusion, Act would have clearly said your office will be till the conclusion of AGM, like what they said in the auditors. When the lawmaker is clear about auditor, then why he will be vague about the directors? He would have said that very clearly. So nothing is said commencement. Since they said conclusion there, we need to take conclusion. For auditors, for the additional director, commencement of AGM. Now 10 a.m. AGM starts. 9:50 I am a additional director. 51 additional director. 55 additional director. 57 additional director. 59 additional director. 10 o'clock I am a person. 10 o'clock I am what? Person. Once I become a person, now answer my question. 10 o'clock, that means when AGM starts, I'm an additional director or I'm a person? I'm a person, obviously. Now answer my question. Total total dash will be divided into two parts, rotational, non-rotational. Who will be divided? Total directors will be divided into rotation, non-rotation at the AGM. That means at the AGM, I am a rotational, non-rotational decided means first I should be a director. I am a director person when the AGM starts. I am a person. That's why I will be excluded from 152. That's why additional directors will be excluded from the total. That's the common sense answer. Okay. So next issue, fourth one. So these are all certain other issues I want to cover. Though in the revision chart it is not there. Why I am telling this is if you have missed anything, at least in this way you can cover up. Okay. Next. Um, can additional director become a managing director? Yes, you can become a managing director by complying with the provisions of section number 196. But generally no one will do that. Even if you do that, no problem. Once additional director tenure is completed, you will become a person, and if you comply immediately if you comply with the 160 section and become a normal director, then no problem, you can continue as an MD. Next, I am an additional director, completed the tenure at the AGM. Okay, I want to become a normal director. How to become? Directly additional director will not become rotation, non-rotation. In this AGM, where you become a person, 14 days before issue a notice, and you become 14 days before the AGM, you issue a notice. AGM starts, you become a person. Your notice will be put up in the AGM, and you will become a director, and you can continue as a regular director under 160. That's the way. So these are certain important core points that I want to convey in the revision. Next issue, alternate director. So now we completed one director again. What is the one directorship that we completed now? Additional director we completed. Next issue will be the alternate director. So next, alternate director. Applicability of the section. Section applies to all the companies, whether public or private. Next one, power to appoint with whom? Board of directors only. Board can only appoint. Okay, board will get the additional director. Board will get the power from articles, but alternate, board will get powers from any of the two sources, either from articles. If articles is silent, you need not alter articles. Take the one-time approval from shareholders ordinary resolution. Okay. So that's the point. Next, alternate director. Okay, we can read this later. First, applicability of section 150 to 6 and alternate. Alternate director is also excluded because section itself in the third proviso will clearly tell any reappointment under this particular act will apply to the original and not to the alternate. That means alternate director is not subjected to retirement. Therefore, he is a excluded director. You can't make him non-rotational director. Non-rotational means when the tenure is having some longevity, you can make him as a non-rotational. Alternate director tenure will be completed upon return of the original director. Then why to make him non-rotational? Am I clear or not? So, next one, nature of section will be optional. Now, this is very important, event of appointment. What is the event of appointment of an additional director? Sorry, this is not additional, alternate. What is the event of appointment of an alternate director? First thing is absence of original director for not less than 3 months from India. That means he should be absent from India for a period of not less than how many months? 3 months. Then only the section will get attracted. Next one. Nature of board's power. That means like additional director, board of directors may appoint either at a board meeting or even by a RBC. Appointment for a fixed tenure like additional director possible? Not possible. Next one. Capacity of additional alternate director. Alternate director is a proxy to original director. Just now, 1 hour back, when we discussed about the basic concept, I said there is a section called as duties of director. In that shall not assign the office. Original director can't appoint alternate. Board has to appoint. He will work in his own capacity. He is not a proxy to original director. Okay. Next one. Who is disqualified from appointment of an alternate director? Sorry, sometimes it happens, so please consider this. Who is disqualified from appointment of a alternate director? Who is already an alternate director in the company and director in the same company? That means, see here, you can understand in this way. Director plus director, alternate director plus director, alternate director plus alternate director, which in the same company, all these three. I am a director in one company. Okay, can I become again director in that company? No, and this is not covered by this section. I am a director in A Limited. Can I become director in B Limited? Yes, this is possible. I am an alternate director in A Limited. Okay, I want to become another director in B Limited. Possible? Not possible. Because if you are already a director, if you are already an alternate director, you can't again become director, and vice versa also apply. Alternate director, not possible. In the same company, you can become alternate director in X Limited and alternate director in Y Limited. Simply in one line answer, I can conclude like this. Dual directorship is not possible. That's all. Next one. For every directorship, we need to check the mode of appointment and tenure of office. What is the tenure of office of an alternate director? I will continue till that person returns to India, or permissibility is lost, whichever is earlier. So what do you mean by permissibility? Original director left India and went to USA. He became insolvent there. Okay. Court in India passed an insolvency order against the person and declared that he is insolvent during his visit outside India. Now tell me, once he is insolvent, he is qualified or disqualified? Disqualified. That means he vacated the office or not? Yes. Once he vacated, how can I continue? I stepped into the company because of that person. When that person itself don't have permissibility to continue, how can I continue in this office? Therefore, if the permissibility is lost, alternate director can't continue. Or permissibility not lost, he is sound mind and he is solvent, everything is there, but he returned back to India. Once he returned, why I will be sitting? I came for him. If once he come, I have to leave. That means technically, to understand, alternate director is a byrunner. That means you are on behalf of you, I'm standing here. When I am running, you don't run. When you are running, I should not run. Both of them can't act together. Many people will get it out, and the last exam question was also asked on the same thing. Can which when resolution is passed, who will when resolution is passed, it will be binding on whom? Additional alternate or original director. Likewise, the question was asked in the last attempt. Simple answer: always acts done by whom, it will be binding on them. Original director acted, binding on original director. Alternate director acted, binding on alternate director only. That means for the frauds done by alternate, original will not be liable. For the frauds done by original, alternate will not be liable. Both are acting in their own different capacity. So alternate director also of the same sort. So this is the main idea behind. If you want to appoint alternate director for independent director, there is an independent director. He left India and want to go outside. Yes, you can go. 5 months trip. Okay, you go. But whoever you appoint as a independent alternate director in the case of independent director, he should also qualify the independence criteria. This is what's said in this section. So in a nutshell, okay, so if you refer our original class material, that means the material study material what we give as a textbook in the class, there will be totally 35 questions on alternate director. It requires a lot of analysis, etc. Revision sessions concentrates on a overall clarification of the concept. That means at this point of time, how can we spend 1.5 hours on alternate director? So this session will be helping you definitely to recap whatever you have read already. Extraordinary points and board clarifications, exam questions, etc. Whatever you find in our material that we need to read. These are the main points that everyone has to read in terms of alternate director concept. Am I clear? So many questions I gave you in our study material, in our material in the classroom. That means alternate director said that he will be outside for 5 months, but he returns back within 3 months, within 2 months itself. What will happen? Or he said that he will leave only for 2 months, but he didn't return even after 5 months. What will happen? Am I clear or not, everyone? So all these things also we discussed in the class. And next one, can we appoint NRI for an alternate director? Next one, can we appoint NRI as an alternate director? Can we appoint alternate director for NRI director? Many concepts we read in the class. All these will take a lot of time to make analysis first. So therefore, not going into that, let's first cover the main contents of the section and examination applicability. So therefore, applicability of the section, all the companies. Next one, alternate director for independent director should also qualify independence. Power to appoint to a board of directors. Applicability 150 to 6 alternate director will be excluded. Nature of section will be optional. And next one, event of appointment. Original director absent from India for not less than 3 months. And fixed tenure appointment possible, not possible. Appointment at board meeting or RBC, either at a board meeting or RBC. Next one, capacity of additional director is a proxy, not a proxy. Next one, tenure of office, permissible or return, whichever is earlier. And when he will be, who is disqualified to become alternate director? If you are already an alternate director in one company, and if you are already a director in one company, that means in one company you want to get appointed as alternate. In that same company, if you are already an alternate director or even a normal director, you can't get appointed as an alternate director. That means in one company you can't hold dual directorships. Next one, nominee director. Okay, nominee director. Before we start with nominee, I want to tell you one thing. Who will appoint nominee director? For example, company has taken a loan from a bank. Say it is SBI. Company has taken a loan from a bank, SBI. Loan worth rupees 250 crore. In the SBI, there is an act called as SBI Act 1956. That act said that if SBI gives loan to any entity with beyond an amount of rupees 200 crores, it has to appoint a nominee who should become the director in the board of that particular company. Simply, we can call nominee director appointment is mandatory. Now, listen carefully. Whenever SBI gives a loan to a company, SBI will be worried how the company is going to use the fund. Yes or no? Therefore, SBI, banks and financial institutions will appoint nominee directors. Like this, you should not think. This is a wrong notion. Financial institutions and banks will not appoint nominee directors. They will nominate. They will not appoint. Why a third party will make appointment in my company? SBI will only nominate. Bank will nominate. Financial institution nominate. Financial institutions will not appoint. You nominate a person. He is your nominee. When your nominee is appointed by our company as a director, he become a nominee director. Okay. Now try to understand clearly. There are certain circumstances to understand. First thing, applicability, public and private company. Next one, mode of appointment. Appointing authority will be board of directors. Nomination will be made as per the act or agreement by a bank or financial institution. Sir, I didn't understand. This is the question by many. Okay, I will prepare a chart for easy understanding because many people are getting doubts with regard to the nominee director concept. So, types of power in articles. Power derived from AOA. That means if the AOA is silent, you can't appoint a nominee director in a company. So anyway, I will explain you in this way. See here. Nominee director. See here. Nominee director has two stages. Stage 1, stage 2. Nominee director. Stage 1 will be nomination. Stage 2 will be appointment. Stage 1. Nomination has to be made. Yes or no? So therefore, stage 1 is all about a nomination. Stage 2 is all about a appointment. That means first nominate and then appoint. Okay. First one. Who has to nominate? This is the main point. See here. Act, agreement, act or a agreement, and to appoint, act, agreement. This is stage 1. To appoint, articles of association has to give the permission. Now listen. Case 1, 2, 3, 4, 5, 6, 7, 8. 8 different questions can be asked in exam. So listen. Let me first explain the idea behind. Later you can answer this. Whenever you are taking loan from a bank or financial institution, we can bifurcate the banks and financial institutions into two types. Banks and financial institutions governed by its own law. Bank and financial institution not governed by its own law. Governed by its own law means what? Many financial institutions and banks, some are there where there is its own act. SBI has SBI Act. LIC has LIC Act. Okay. Next one, IDBA has IDBA Act. UTA is having UTA Act. Some institutions and banks are having their own acts. Some are not having their own acts. This is the situation. Your bank should belong to any of the two. Okay. Now I am taking from SBI. Appointment of nominee director is governed by agreement between SBI and the company taking the loan, or it is there in the act itself. It is there in the act itself. If it is a bank which is not governed by its own act, then they have to write an agreement. Okay. HDFC is there. HDFC Act is not there. Therefore, HDFC and company should enter into an agreement to appoint nominee, and that nominee will be appointed as a director in the company. So therefore, listen carefully. The point that I want to convey is, see here, first, there can be many situations. Act is saying no agreement and articles is allowing me to appoint. Okay, next one. Stage 2 is appointment, stage 1 is nomination. No act, agreement, articles. Act, agreement, and articles. Act, no agreement, but articles is there. Act, no agreement, no. Now answer. In which of the following cases we can appoint a nominee director? First situation, act is permitting me to nominate or not? Yes. Articles is permitting the board to appoint or not? Yes. You can appoint nominee director. Second situation, act is permitting to act is having something or not, or act is governing them or not? No. But there is an agreement or not? Yes. Articles is permitting the board or not? Yes. You can appoint nominee director. Act is saying, and you have also written an agreement, though not needed, and articles is also allowing me, you can appoint a nominee director. Act not there, agreement not there, but articles is saying that you can appoint. No appointment because nomination is not made properly. And in all the other few 3-4 cases, it is not possible because articles is silent. So board can't appoint nominee director unless derived from the article. This is the meaning. Okay. Next issue. Nature of appointment. Board of directors either at a board meeting or RBC. Next one. Tenure of office. Till when he can continue. Act is silent, but you can understand in this way. First one, expiry of the term by any reason. That means he nominee director disqualified, vacate the office. Nominee director insolvent, vacate the office. Dim cancel, vacate the office. His own disqualifications can lead any expiry or repayment of loan. You came inside to the company because I have taken a loan. When I repay the loan, why again you are doing overaction in my company? Go out. No, no, sir, I want to become director in your company. Then apply under 160. But as of now, repayment of loan. Next one. Who has nominated the nominee director? Bank. If that bank cancels the nomination, then you can't continue as a nominee director. Whichever is earlier will be the expiry date of office of nominee director. Everyone up to here understood the concept clearly? So the next concept is casual vacancy director. Okay. In the same way, let's complete this as well. So first one, applicability of the section. As it is, section applies to all the companies whether public or private. This was added by amendment. Previously, it applicable only for public. Now it is applicable for both public and private companies. Mode of appointment. If articles specify, follow the articles and fill casual vacancy. Whatever the mode article specify. If the articles is silent, board of directors will appoint at a board meeting. Now RBC not possible. For whom? Casual vacancy director. Next one. Tenure of office. Till when he can continue. Chairman, everyone. Applicable to which company? Both public and private. And appointment by whom? Article specify, follow that mode. If article is silent, board will appoint at a board meeting, no RBC. Next one, tenure. He can continue up to the tenure of original director. For example, original director appointed today for 5 years. Okay, today for 5 years. Okay, today for 5 years. Under 160. Example. Okay, today for 5 years. He vacated after 3 months. And I appointed at the exactly for example 1 month after the vacation of original director. From there he will continue for 4 years and 6 months. That means because he completed only 4 months, another 4 years and 6 months tenure will be there for him to continue. That means if the office of original director had not been vacated, if the original director's office had not been vacated, if at all the office of original director is not vacated because of a casual vacancy, till when he would have continued, a date will be there. Till then he will be continuing as a director. Sir, original director appointed, he is appointed as a rotational director. After 2 years, AGM might have been held. At the 2 years AGM that is being held, there he will become retiring director. There he may be appointed, he may not be appointed. How do you know all these futuristic issues? Therefore, casual vacancy director will be always non-rotational director, irrespective of original director. Original director may be rotational, original director may be non-rotational. Casual vacancy director always stands non-rotational because he will continue till the tenure of original. Because how can you interpret that he is a rotational director? To become a rotational director, there are only 2 chances available. First, you get appointed in a general meeting, or section should clearly tell that you are a rotational director appointed by some other route. Just now in 152.6 we learned, so read the BARAC properly. That's why. So revision session also I made this point very clear when we are discussing about 152. How to become rotational, general meeting, or otherwise provided in the act expressly. Here it is not clearly said that he is rotational and it is not general meeting. Then how can you call him as a rotational? So articles will specify casual vacancy. Here appointment will be made by articles, So therefore, anyway, one thing you have to make it clear: the office of a casual vacancy director will be till the office of original director. Original director may be rotational director, original director may be non-rotational director, but casual vacancy director is always non-rotational. Because if original director is non-rotational, but some people will have a wrong notion. Non-rotational director means a permanent director. 100% wrong. I will show you the practical companies which I am dealing with, where non-rotational director, rotational director means what? What is the difference between them? Rotational director will be liable to retire by rotation during the tenure of 5 years or 6 years or 8 years. For example, I was appointed for director as a 8 years director. Okay, rotational director means during these 8 years I will be coming into this what to say, musical chairs concept. That means I will come up for rotation, retirement, stand, sit, etc. Non-rotational director during this 8 years tenure will not face the shareholders. That does not mean that non-rotational director means permanent director. There is no concept called as permanent directors under Companies Act. You can't appoint like that. Okay, so I'm a non-rotational director for 5 years. I have resigned and went away at the end of first year. Then what the casual vacancy director whom you appoint can continue for the remaining 4 years period. If you appoint him after 6 months after vacation, he will continue for 3 years and 6 months. Am I clear or not? If the original is a non-rotational, how can you make alternate casual vacancy as a rotational director? Not possible. So therefore, always fix in mind casual vacancy director is a non-rotational director. Next one. Power to appoint in article subjected or derived, it is a subjected power. That means if the article specify, follow articles. If articles is silent, section will apply. On subjected to articles and derived by articles, we can define it for almost 15-20 minutes, but we don't have that much time to discuss on all those areas as of now. So event of appointment, creation of a casual vacancy. And next one, can all casual vacancies be filled under this section? Only casual vacancy created in the office of a director appointed by company in a general meeting and whose office expires before his term expires in normal course. When all the four conditions are satisfied, then only you can fill that casual vacancy. That means first one, there is a casual vacancy. In whose office? Director's office, who was appointed at a general meeting, and the casual vacancy should create after tenure, before tenure, then only you can fill under this section. That means if I am appointed at a board of directors meeting, can I be filled? No. That means casual vacancy in the office of a alternate director, additional director, casual vacancy director for that case, nominee director, first director cannot be filled under this section. 160 appointment can only be filled. That's the idea behind casual vacancy. So please have a look. Let us make a quick revision. You can also put your Bear Act with you. Whatever the points I covered are only cover points that will be there in the Bear Act. So applicability of the section, both public and private company, mode of appointment, articles which I follow the article. If the articles is silent, the board of directors at a board meeting has to fill the casual vacancy. Tenure of office will be up to the tenure of the original director. But in the Bear Act, they will use that the office, he shall not continue, or he shall act as a director up to the date up to which the director in whose place he has been appointed would have held office if it had not been vacated. That will be the point. Next one, power in articles. It is subjected to articles. If articles specify, follow articles. If articles is silent, section will apply. Anyway, you can appoint casual vacancy director. Event of appointment, creation of a casual vacancy. Can all the casual vacancies be filled under this section? No. Casual vacancy in the office of original director appointed by the company in a general meeting is only filled. Okay. Now, a person is appointed as a original director. Okay. He resigned, resulted in a casual vacancy. Okay, I filled in accordance with 161 subsection 4. Again, he vacated and created a casual vacancy. Can this be filled? No. Casual vacancy in the office of casual vacancy director cannot be filled. Only one time in the original director's general meeting appointment director only can be filled. This is one question that was asked in the last but one attempt for 4 months or 5 months. So this is the end of board appointments. Next one, statutory appointments. There are two statutory appointments. Technically, three statutory appointments are there: Indian women director, Indian resident director, and independent director. Okay, independent director we will be separately covering that. First, we will be covering Indian resident and women director concept. So see here, statutory appointments: Indian resident, women. Indian resident applicable to which companies? All the companies. Which companies are required to appoint? All companies are required to appoint at least one director who stays in India for not less than 182 days during the financial year. That means this condition has to be checked once you complete financial year. 2021 financial year completes on 31st March. As on 31st March, we need to check whether at least one director is there in the company for more than who stays in India, who stays in India for not less than 182 days during that financial year. Then we need to check that condition. That means before financial year or during the financial year, you should not check. Let the financial year continue fully. Let the financial year complete. 31st March came. On 31st March, let's have a look. Is there any one person as a director in the company who stays in India for not less than 182 days? Okay, if that be the case, condition is satisfied. Okay, so at least one director of the company must stay for not less than 182 days. Next issue. Situation in case of a newly incorporated company. My company incorporated in the month of December. Okay, December 31st incorporated. January, February, March, only 3 months is there. 182 days requirement is required for 365 days here. I've been there in my company got incorporated itself 91 days prior. If it is 182 for 365, what for 91? You have to proportionately count and calculate. In case of newly incorporated companies, proportionally you need to calculate. This is what section want to tell. Next issue, women director. Women director applicable to companies. Okay, whenever it is applicable to companies means which companies we need to check now. Conditional applicability. At least one women director shall be appointed. By which company? Companies will be divided into two parts: public, private. Private not applicable. Public is again divided into two categories: listed, unlisted. Unlisted, unspecified, unlisted again not applicable. So listed applicable, and unlisted specified, unspecified branches will be there. Unspecified not applicable. Specified means paid up share capital of not less than 100 crores and or turnover of or not end or turnover of rupees 300 crores minimum. They have to appoint women director. Now tell me, companies will be divided into how many categories? Two categories: listed and public. Private not applicable. Public again divided into two parts: listed, unlisted. Unlisted again divided into two parts: specified, unspecified. Listed public company required or not? Yes. Unlisted non-specified required or not? No. Unlisted specified required or not? Yes, provided it is having a paid up share capital of not less than 100 crores and or turnover of rupees 300 crores. Required to appoint women director. If at all any vacancy is created in the office of women director, then what to do? Fill it as soon as possible, but not later than 3 months from the date of vacancy or immediate next board meeting, whichever is later. Not earlier, whichever is later. 3 months from the date of vacancy or immediate next board meeting, whichever is later. Sir, 3 months comes first, then wait till the board meeting. Sir, board meeting comes first, then wait till 3 months. Sir, both are there, both not satisfied, then you will be liable for a penalty under 172. So this is the idea behind the women director section. Okay, I covered only the sections content. Inside we can dig into the issues and spend lot of time, but that is not the idea behind the revision classes. So this is the completion of another appointment called as a women director. So there is another one directorship to cover, that's called as independent director. So let's have a look into this. Independent director. Independent director section is highly asked section in the set of directors. I think if I'm not wrong, independent director section was asked almost 6 times in the last 9 attempts. Okay, in the last 9 attempts, independent director section itself was asked for 6 times in examination. That much important it will be. Generally, a question will be there from independent directors. Some point he will ask in examination. So let's have a look into the concept of independent director. Independent directors, many points are there. Let's go step by step. First one, applicability of independent director section. To which companies it is applicable? Again, companies are broadly classified into two parts. Okay, companies are broadly classified into two parts. One second. Okay, see here. Companies are broadly classified into two parts. First one, public company and private limited company. Public company, private limited company, private company, the section itself does not apply. So there are two types of companies. One is public, another one is private. Private companies are independent directors concept does not apply. No sir, my company is a public limited company. Again divided into two parts: listed, unlisted. Okay, if it is listed, generally it applies without any appeal criteria, not appeal, applicability criteria. Without any applicability criteria. That means paid up capital requirement, turnover requirement, or what to say, borrowings requirement. Nothing you need to see. Directly, blatantly, you can tell one word answer. Section applies. If it is unlisted, again it is divided into two parts. First one, satisfying the eligibility criteria, not satisfying the eligibility criteria. If it is an unlisted company satisfying the eligibility criteria, again you will be discussing into two parts. Whether that unlisted eligible company is a joint venture company or a wholly owned subsidiary or a dormant. If that be the case, again not required. In case of all other companies, if the paid up share capital is rupees 10 crores or more, or turnover is rupees 100 crores or more, or the borrowings outstanding borrowings, debentures or deposits exceeding 50 crores, that's very important, exceeding 50 crores, such companies are required to appoint independent directors. Those who didn't understand the wordings, at least see the chart once. Thereafter I will make the rediscussion on the concept. So I think it's time for us to continue. Listen, companies will be broadly classified into two parts: public company, private company. Private company section does not apply. Public company we divide it into two parts: listed, unlisted. Listed, generally applicable. Unlisted, divided into two parts: specified, unspecified. Unspecified, not applicable. Specified, again divided into two parts. If it is specified unlisted company but being a joint venture company or a wholly owned subsidiary or a dormant company, again section does not apply. In all other cases, if the paid up share capital is more, if the paid up share capital is not less than 10 crore, or turnover is not less than 100 crore, or if the debentures outstanding or borrowings and deposits aggregate exceeds 50 crores, in all these three cases, any of these three cases, it is mandatory to appoint an independent director. Okay, next one. If it is not satisfying the eligibility criteria, unlisted company, it is not applicable. Next issue. Number of independent directors. If it is a listed public company, not less than 1/3. In all other cases, it will be two independent directors. This is a transitory provision. Just have a look. Not applicable today. Expires in 2015 year itself. Liability of independent directors, subsection number 12. I am not going by the sequence of section. I am going by a right sequence for easy understanding. Listen first. In a company, there are two types of directors. One will be executive, another will be non-executive. Executive directors are those directors who will be actively participating into the day-to-day affairs of a company. Non-executive directors are those directors who comes only to the board meeting, share the knowledge, take sitting fee, leave the company. Now, most of the directors in a company will be non-executive. Executive will be hardly 2 or 3 directors will be executive directors. Remaining all will come only to the board meetings, share the knowledge, take sitting fee, leave the company. That's the idea behind the non-executive directors and executive directors. Why I'm discussing about this? Independent director is a non-executive director. You can't make independent director as executive director, because once you target and label him as executive, he will get interest in the day-to-day affairs, which makes him dependent and not independent. So therefore, independent director is always a non-executive directors. Non-executive directors will attend board meeting or will attend to everyday transactions, board meetings. Therefore, they will be attached to frauds, liabilities, etc. only if something happens through a board meeting or board resolutions where they vote. Okay, let's try to understand this. Most of these students who are listening to this particular point now may not be aware. I'm not telling shall not be. Chance is there, because everyone need not read last subsection of independent director. Because of that reason, I put that in the first place. Okay, listen carefully to the independent directors concept. Directors are there: active or executive, passive or non-executive. These people will participate in day to day. These people participate only in the board meetings. Liable in all cases. Independent director comes into this set. Now listen. Some decision taken in a company. What taken? Some decision is taken in a company. That decision is taken by MD directly. Then it is not through a board. Then independent director or non-executive director not liable. No, it come to a board meeting and taken a decision. This becomes a through board. Okay, just coming to the board, independent director will be liable? No. To that board meeting, he should have a knowledge. If without his knowledge that board meeting is held, or he is absent to that board meeting, again he is not liable. He attended the board meeting, he have the knowledge, then independent director or non-executive director liable? No. In that resolution, the resolution which turned to be a fraudulent resolution, to that resolution the independent director or non-executive director should consent first, then only liable. Not consented also liable. if it happens with a connivance. Consent means I'm giving consent for doing wrong. Connivance means I'm not doing wrong, but I'm allowing others to do wrong. That means a decision is taken at a board meeting. If I vote against, that wouldn't have happened. I will keep silence and allow others to vote in favor. That means connivance means allowing others to do. Even if you don't consent, if it happens through your connivance, again you are liable. Without connivance means not liable. Everyone, I request, please write down this chart in your notes. So next issue, remuneration. Can we pay remuneration to independent director? Remuneration will not make independent as dependent. Remuneration will be given for work done, not to make him a slave. Okay. So therefore, remuneration. What are eligibilities and what are ineligibilities? Eligibility. Sitting fees he can take. Expenses reimbursement for attending board meeting. Profit linked commission under section number 197 he can take. Okay. But he is not eligible for stock options. Why stock options are not possible? It will fix an obligation to stay in a company, which differs the independence. Next one, stock option is at the convenience of the particular person, and it will be converted into equity shares and will get voting rights, which make him non-independent. For that reason, it is not possible. Status of independent director. Independent director shall be excluded from the total directors in terms of, like additional, like alternate independent is also excluded. Mode of appointment of independent director. This is important. Listen. Mode of appointment. How the independent director is appointment? 149 section which deals with independent director is silent on this. Okay. We have two options. Option 1, option 2. Option 1, directly make an appointment or selection and appointment. Directly make an appointment means the board of directors of the company or nomination remuneration committee know a very good person in the industry who is independent. That means you don't have any kind of dependence with the company. They can directly approach him and appoint. Okay. In that case, comply with the provisions of 160 and appoint him. But independent director, that means a proposal to appoint him. This point I have to explain in much more clarity. Listen carefully. Women director concept completed. Women director appointment is optional or mandatory? Mandatory appointment. It is not optional. It is pakka mandatory section. If we come into the applicability criteria. Now tell me, my company is in a dire need of a women director. They have to appoint. Now tell me, obligation to appoint women director is for the company concerned or for the women concerned? Mrs. X is there. Okay. Mrs. A is there. Let's take like that. Mrs. A is there. She is a qualified IIT. Now answer, being a IITian, she has enormous opportunities in the industry. One company approached her. Tata Iron and Steel Company approached her. They asked, ma'am, do you like to continue or do you like to get appointed as a women director in our company? Because you are from IIT from Kharagpur, which will be significantly researching on the metallurgy and other metals. So our company is also in the steel industry. We want your suggestions at the board meetings. So can you become a women director for our company? They requested Mrs. A. And she also shown her consent saying that, okay, Tata company means it's a prestige also to me. It will be a overwhelming prestige for even for the person who is getting appointed. So therefore, I will be accepting. Now tell me, obligation to appoint women director is there for company, is there for women? That means if the company is not approaching her, her life is gone. No, if company does not have her, life of company will be gone because there will be no women director, sections will be contravened. That means simply you can convey one important point in this connection. Who has a need? Company is in the need of women or women is in the need of company? Women director is in the need of a company or company is in the need of a women director to get appointed. Company has a need to appoint women director, not the women does not have any need to go to the company. She has enormous opportunities even though that company does not appoint her as an independent director. That means she has more opportunities, but company has only option to appoint a women director. Now answer, if Tata company approaches a women director or a woman, Mrs. A, and ask her, ma'am, please get appointed as an independent director or a women director in our company. Who has a need now? Company. Then why I will pay 1 lakh? There is no logic here. 160 section, you have to bring her into the company. If you bring under 160, she has to bring 1 lakh. Avasaran needi. Why I have to pay 1 lakh? Need is for you. Why I should bring 1 lakh? Same even with independent director. Our independent director will be appointed with the request of the board of directors. Then why I should pay 1 lakh rupee? Nonsense. I will not pay. You say you go for another independent director. So therefore, this is what they want to convey. That's why a recent amendment said that this 1 lakh is exempted. Next issue. Selection. This is one way. Okay, if you already know a industry person who is independent, but independent directors are not that easily found. In such cases, like matrimony, why matrimony concept is there, shadi.com, etc. Need is when you already know a girl or a boy directly, again after knowing her or him, you will again go to matrimony and search for her. If directly a person is available, we can directly contact her parents or his parents. But if the person you don't have any other likely commitments with any other person, okay, no creativity, listen. So the point is, if you are not already committed, okay, then what to do? Then you have to search for a boy or a girl who satisfies your requirement criteria in terms of qualifications. Okay, in terms of qualifications, you need a CA, CS, CMA, advocate, etc., 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 everything, whatever available in this globe. You want that qualified person. For that, can you directly have a search? So you cannot. In such cases, approach a matrimony. Same thing. I want an independent director, and I know one person who is independent in all respects. Select him. But I don't know in the second situation. Then approach a matrimony. In Companies Act, the matrimony is called as a database, and that matrimony agent is MCA. Okay, so MCA has started a concept called as a data bank. From the data bank, you can select the names of independent directors. So an independent director may be selected from a data bank which contains the names, addresses, and qualifications of all persons who are eligible and willing to act as independent director. From that, appointment will be made by a letter of appointment. By letter of appointment, you will be appointed, and later your appointment will be put before the shareholders for approval under 152(2). This is a mode of appointment. Tenure of office. Subsection 1011 will be talking about tenure. Once independent director is appointed, he can continue for a period. For the first time, he can continue for a period not exceeding 5 years. Second tenure, you can get appointed but pass a special resolution. Again continue for 5 years. After that, take a cooling period of 3 years gap. After that, you can be appointed. During this cooling period, you shall not be appointed or associated in the company in any other capacity. Okay, independence, whether you are independent or not, whenever there is a, at the time of appointment, you need to declare that you are independent as a questionnaire and renew at every board meeting in every financial year. Whenever financial year starts 1st April, after that the first meeting, declare that you are independent even then. And when there is any small change in the criteria and there is no change in your independence, declare that. For example, up to 2% of the turnover of the company, if you are contributing up to 2%, no problem. Even though you have some monetary interest, that does not disturb your independence. I purchase goods from the company, which is lesser than 2%. Now, there is a purchase made, monetary interest created, but that does not damage my independence. So therefore, give a modified declaration that when there is a change in the independence already given, say that though I purchased some goods, I didn't lose the independence. So this is what independent director section want to convey. So this is all with the end of appointments of the directors. Okay, that means if you can observe clearly what I said at the beginning of the story, we have certain list of directors. First directors we completed, right of a person we completed, rotation, non-rotation, additional, alternate, casual vacancy, nominee, women, Indian resident, and independent director. We completed all this. Okay, as a quick revision in a nutshell. First, every directorship we need to check two things. One is the mode of appointment. Second one is the tenure of office. First directors of the company will be appointed by the board by the articles of association. Write the names. If the articles is silent, the subscribers to the memorandum who are individuals shall be deemed to be the first directors of the company until the directors are duly appointed. Tenure of office. If you are a first director appointed officially through the articles of association, you need not vacate at the first AGM. Go to the first AGM and you will be nominated either as a rotational director, non-rotational director. If you are deemed first director, first conduct a EGM before the first AGM AGM, and after the date of incorporation, there the deemed first director shall vacate the office, place will become vacant, and appoint the directors under 160 who are called as first directors and who will go up to the first AGM. There they will be nominated as a rotational director, non-rotational director under section 152, subsection 6, clause C. This is what's seen in the first director's concept. 160. 160 section gives a chance for a person to get appointed as a director. First one, this is applicable to a public company only, and he should be already qualified and not disqualified, and he should send a notice to the company not less than 4 days before the meeting at the registered office of the company. Member can propose himself, member can propose others can propose themselves, others cannot propose others. 14 days before the meeting, along with the deposit of rupees 1 lakh, send it, and it will be refunded if you get more than 25% of the total valid votes cast, or if you get elected. And you have to, and the board of directors will receive that 14 days before, and board has to communicate that to the other members of the company either by serving individual notices or 2 newspapers. One will be English and the one will be local vernacular language. The third one will be rotational, non-rotational. Total directors in a public company shall be divided into two categories at an annual general meeting. First one is rotational director, another one is non-rotational director. Rotational director, 3 points. Meaning of rotational director, how many rotational directors, and how appointed. So rotational directors are those directors whose office is liable to retire by rotation, and not less than 2/3 of the total number of directors shall be rotational director and will be appointed by the general meeting or any other mode expressly provided in the act. Non-rotational directors are those directors whose office is not liable to retire by rotation, and not more than 1/3 of the total number of directors shall be non-rotational, and they will be appointed either at a general meeting or by the articles. Completed. Next one, at the first annual general meeting of the company and at every subsequent annual general meeting of the company, 1/3 of such of the directors who are called as rotational directors shall actually retire. Who shall retire first? Those who have been longest in office since their last appointment shall retire first, and 2 appointments made on a same day, and if there is any confusion on whom to retire, who shall retire first, in such cases shall be decided by agreement. In the absence, it will be determined by the draw of lots. At the annual general meeting of a company, any of the 2 things can happen. The retiring director must be reappointed, or some other person should be appointed in his place, or pass a resolution not to fill the vacancy. If none of the 3 things take effect, the meeting will be adjourned. Even if the adjourned meeting, no decision has been taken due to confused state of mind, then again second adjournment is not possible. The retiring director shall be deemed to have been reappointed, but the deemed reappointment shall not apply if the unwillingness is shown, or resolution is already put to meeting and lost in the original meeting or in the adjourned meeting. And third one, 162 is applicable to the case ordinary special resolution is required, or where he is disqualified from getting appointed. This is what we seen in the rotation, non-rotation. Additional director. Additional director means the articles of a company may confer on the board of directors the power to appoint any person who, not being a person who fails to get appointed by the company in a general meeting, as an additional director at any time, who shall hold office up to the date of next annual general meeting or the last date on which the AGM should have been held, whichever is earlier. Next one, alternate director. Alternate director will be appointed either by the board of directors, appointed only by the board of directors, either by deriving the power from the articles or by the resolution passed by the company in a general meeting. The event of appointment will be absence of the original director from India for not less than 3 months. And you can't get appointed as an alternate director if you are already a director in the company, or if you are already holding a alternate directorship for any other director in the same company. Next one, independent director, alternate director. If you want to appoint alternate director for an independent director, that new person should also qualify the independence criteria. Next one, what is the tenure of office? You can continue up to the permissibility or return back to India, whichever is earlier. And for the purposes of retirement and reappointment, whose tenure will be taken, original and not the alternate. Next issue, nominee director. Nominee director means board of directors has to appoint nominee directors upon nomination made by the bank or financial institution as per the agreement or as per the act. And next issue, casual vacancy director. In case of a public company or private company, if any casual vacancy is created in the office of a director appointed by the company in a general meeting, whose course of tenure of office expires in a normal course, before that if it expires by death, resignation, removal, etc., because of that if it creates any casual vacancy, that has to be filled in accordance with articles. If the articles is held, board of directors at a board meeting has to fill the casual vacancy. One important point I forgot to tell previously, casual vacancy means any vacancy other than by retirement. That means 150 to 6 the retirement is there na. There if you see where the word used is the vacancy, not casual vacancy. That is a vacancy. Other than 150 to 6, everything is a casual vacancy. Resignation, removal, death, disqualification, etc. Everything. Vacation, all these things. But not reappointed under 150 to 6 creates a vacancy, not a casual vacancy. Okay, that's the next issue. And after that, what is the tenure of office of a casual vacancy director? He can continue up to the date up to which the director in whose place he has been appointed would have held office if it had not been vacated. Next issue, casual vacancy also completed. Women director. Women director appointment is mandatory in case of listed companies, and it is mandatory in case of specified unlisted company which is having a paid up capital of rupees 100 crores or more, or turnover of rupees 300 crores or more. Any vacancy in the office of a women director shall be filled. within 3 months or next board meeting, whichever is later. Indian resident director. Every company shall have at least one director who stayed in India for not less than 182 days in the preceding financial year. And in case of newly incorporated company, count must be taken proportionately. Independent directors, just now we completed the concept. This is the end of the director's appointment.